Let's ask Ronald Chapman II tonight. He's a constitutional attorney. He has won cases at the Supreme Court. Mr. Chapman, we have seen this court is willing to dismantle precedent, sometimes with a bulldozer. It's not brick by brick always. But the Chief Justice, John Roberts, he's usually more of an incrementalist. What do you make of him giving Trump some extra time on the taxes?
Well, thank you very much for having me. I think that this actually is an incrementalist play. What Justice Roberts did in this case, given that he oversees the D.C. Circuit and injunctions that are coming out of it, is he said that he would put an injunction in place to prevent the taxes from being released until a response is filed and the court can decide the issue later. Funny enough, later happens to be after the midterm elections. And if the Republicans take the House after the midterms, that means that the request for the tax records may be withdrawn, and in that case, the Supreme Court may not have to hear this case. So very safe play by Chief Justice Roberts here. It's very possible that taxes will not have to be released and that the Supreme Court will not have to take a stance on that, which I think is exactly what Justice Roberts wants to do when faced with a relatively political topic.
Yeah, whenever he's writing the ultimate decision, he seems to find these little technicalities many times. So let's talk about one big case this term, affirmative action in college admissions. It appears to be on the chopping block. Little history many people don't realize is in 2003, Sandra Day O'Connor said it would be gone by 2028 in all likelihood. So we're a few years ahead of schedule. Gay marriage, though, that also happened a few years ahead of schedule. That sometimes occurs. Is this a radical possibility that it would go away?
Strangely enough, these cases were filed in 2014 and took a long time to get to the Supreme Court here. And now they're finally at the court a little bit before Justice O'Connor's Grutter decision, which gave affirmative action a lifespan of about 25 years. We know that there are many members of the court right now, Justice Thomas probably leading the pack on being opposed to affirmative action. And I do expect that we will likely see a 6-3 majority in the cases in which Justice Jackson is involved in, and likely a smaller liberal majority, or I'm sorry, a smaller a liberal membership of the court on the one case in which she's recused in. But going back to the affirmative action decision, this is really about equal protection. And whenever there's an equal protection challenge, the court has to ask whether or not there's a compelling government interest for this law or for this viewpoint to be in place. And here the question is diversity a compelling government interest? Sandra Day O'Connor, Justice O'Connor, said it is a compelling government interest right now. We'll give it to you. But we hope that you can create policies within the next 25 years so that you won't have to look towards race-based admissions as being a guiding factor. And so the question that the court will have to ask right now is, what has been done in affirmative action in the past that makes it a compelling government interest? And what does the future look like in terms of its impact on education and diversity if there is no race-based challenges? Justice Thomas, very interestingly, even questioned the definition of what diversity is. Sort of hinting to the fact that most of the things that people point to that indicate diversity as a compelling government interest are really related to socioeconomic class. Justice Gorsuch went on further to even suggest that there may be other policies that should have been reversed, like allowing the sons and daughters of alumnus in, or allowing athletes preferential treatment.
At this moment, whose court is this? It doesn't seem like it's John Roberts' court at this moment. In some ways, Clarence Thomas, he seems to have sway over the affirmative action discussions we're having now, the abortion outcomes, although he'd probably have gone further, he said. Who is leading this court?
Great question. We've seen Justice Thomas certainly wake up over the last couple of years. I mean, he didn't ask a question from the bench for something like 15 years. And now, since COVID began, he's always the first to ask questions, and he regularly pipes up. That being said, this is still very much Chief Justice Roberts' court. When we've seen his opinions, a lot of people think he might have swayed a little bit more towards the liberal side, or maybe more moderate. But that really isn't what history has shown for Chief Justice Roberts. In his time as the Chief Justice, there have been 21 decisions overturning precedent. Justice Roberts 15 times decided for the conservatives on those precedent overturning decisions. So he very much is the conservative. He very much is in the majority of the court right now, and he will certainly guide them through many of the conservative decisions we will see from the court. That being said, Justice Roberts' primary position is legitimacy of the court, as you mentioned earlier. And if there is anything that threatens the legitimacy of the court, I'm sure Chief Justice Roberts will try to pull even his conservative brothers and sisters over to the majority side, because his overarching concern for this court is that it will be delegitimized, that its opinions will not be taken seriously, and that it will be seen as a heavily charged political body.
Constitutional attorney Ronald Chapman II, we appreciate your insight.
Thank you so much.